number 22, the people of the state of New York versus Howard Powell. This is on for re-argument. Counsel, give us a moment for our colleagues to settle in. Counsel, good afternoon.
Good afternoon, Your Honor. May it please the Court, Kendra Hutchinson of Appellate Advocates for Appellant Howard Powell. May I have 2 minutes for rebuttal, please, Your Honor?
You may, Ms. Hutchinson.
Thank you very much. Your Honors, here we are again at re-argument, but I really want to start out with very strongly making this point. False confessions are troubling. They are very real. They are found in 15 to 20% of documented false convictions, and yet they are counterintuitive to juries who view confessions as the gold standard of evidence. And for this reason, 10 years ago, this court in Badessi held that expert testimony on this phenomenon should be admitted before a jury in order to educate it. And it held that there is no doubt that experts may offer such valuable testimony about these factors that the relevant scientific community considers to be associated with it.
But counsel, didn't we also say in Badessi there was no Fry hearing, right? Didn't we also say in Badessi that the expert can't testify whether this particular confession is, wrongful, but the proffer must be relevant to the defendant and the interrogation before the court. So it almost seems to me like what you had here was a Badessi hearing. And after this Badessi hearing, the court said, you don't meet the Badessi test. So it's a very different case to me than Badessi. And in fact, the trial court cites Badessi through its opinion and concludes that indeed they didn't meet this standard.
Judge, I agree with you that this is a very different case than Badessi. And I contend that it is because indeed all of the evidence that the expert was going to proffer was actually relevant to the defendant in the interrogation. So Dr. Redlick was going to testify
But is that really what we should be doing? They had a hearing, they had a Badessi hearing, I think here, rather than a Fry hearing. And the trial court concluded no. And our review isn't, we go back and we see, is that right or is that wrong? Was it an abuse of discretion, that ruling, right?
Well,
so why was it an abuse of discretion?
Well, to the extent that we're discussing the relevancy issue, Your Honor, I do think that there has to be a record basis for the court to have made this factual finding as to the relevancy. Here it was undisputed that my client had 30 years worth of documented psychiatric illness, an IQ of 78, and substance abuse history. And so to the extent that that Dr. Redlick was going to proffer testimony about those factors, it seems that there's no record basis for the court's finding that it was irrelevant. As to the further part, I mean, there really are multiple aspects of Badessi at issue here, and Your Honor's getting to the next part here, which is whether or not the court applied the correct standard. And we contend that it did not in determining whether or not this met Fry, whether or not the proffered testimony, whether or not the factors that the expert was proposing to testify about, whether or not it met the Fry standard. We contend that the court below applied a wrong and incorrect legal standard. Here, it cited Daubert, the federal case, which is not concerned, as it is in New York, with just counting votes, counting the experts on one side of the issue or the other, but rather with passing on the reliability. In fact, it even ordered what Your Honor is denominating a Badessi hearing for the purpose of whether or not the jury could be assisted. This court already decided this in Badessi 10 years ago when it held that the jury could be assisted by such.
But not in all cases, right? So it seems to me it's a two-part kind of test. Yes, there are some fundamental issues we could agree on and are accepted, but what if, false confessions, but what if this person then comes in and proffers, left-handed people are more likely to falsely confess? Well, that may not be scientifically accepted, and this person may not be left-handed. So you've got kind of two things going on there, and I think that's what this hearing was about, and it seems like what you're arguing for is more of a blanket rule on false confessions, but that's not Badessi.
You're absolutely right, Your Honor. An expert could come in and testify, that left-handed people commit crimes, or, whatever it is that they wanted to say. But the difference here is that at this Frye hearing, it was a 300-page Frye hearing, numerous scholarly articles of 35 years worth of research, 60 researchers in the field, the preeminent scholar in this field who later on went to become the president of the American Psychological Law Society. A white paper, consensus paper was admitted into evidence.
Well,
All
counsel,
of that.
let's talk about the evidence that was put in front of the judge. And in this context, I'm talking about traditional Frye general acceptance in the relevant scientific community. Dr. Redlick testified during trial, and I think she was speaking specifically about the white paper, that she contributed 2 pieces of literature that formed the basis of the white paper. One was the Alt-Key study, which she subsequently stated had been found flawed by the relevant scientific community and was no longer being used. And she also contributed some literature on the cheating paradigm, which she then subsequently said during the Frye hearing that it was distinguishable from the interrogation that took place in this case, because in the cheating paradigm, the participants were actually encouraged to lie. And I'll even go one further. With respect to a dispositional factor like mental illness, she stated during the Frye hearing that the scientific community was still out on how much mental illness contributes to false confessions. And if there is still an element of this that is a traditional Frye hearing, how can we say that as a matter of law that the judge abused his discretion in holding that this didn't look like it was yet generally accepted in the scientific community?
Well, Your Honor, the white paper cited, I think, like 300 different articles because it was a consensus paper along with 5 other authors. And, and Your Honor is referring to the cross-examination of the district attorney during Dr. Redlick's, testimony, because, of course, they didn't put on an expert and they didn't put on any scholarly articles or any other evidence whatsoever. Yes, Dr. Redlick candidly discussed the fact that the Alt-Key or the crash, these tests that were early on in the science of false confession research, that certain aspects of it had been revised. Science is progress, Your Honor, and scientists constantly revise their hypotheses.
Can I stop you for a second?
Sure.
This is an important point that the judge has raised, because there's some confusion as to what Supreme Court was doing. I don't know if Supreme Court actually ever ruled that, number one, false confessions as a reality, are generally accepted in the relevant scientific community. I don't think they ever made that ruling. I don't think that ruling's ever been made in New York, though. The jurisprudence is kind of sloppy and it's all over the place, but I don't think we've ever really ruled on that. I don't think this court has definitively ruled that either. Do you agree with that or disagree with it?
I think, given that we have a lengthy Frye hearing before you, I think this court is called upon to rule on it. If it did not rule on it,
So my question to you, has anyone ever done it? It's a yes or no question.
As Your Honor knows, we contend that Badesi holds that some such testimony should be admissible without a Frye hearing, but, because Your Honor has a benefit.
The bottom line, respectfully, is no. Nobody's actually ever really done it. So
Yes.
it's generally accepted in the scientific community. That's what I think the judge needs to do first. And the second question, the judge says but the judge, in fairness to the judge says, just like Judge Canataro says, over the people's objection, he says, Dr. Redlick is an expert in this area of false confessions, and I'm going to allow this testimony to go forward. But then he makes a determination that the testimony of the doctor was ultimately not reliable. In other words, and I think the mistake there is that, if there is a mistake, in fairness to him, is that first you got to decide whether it's generally accepted in the scientific community. And secondly, then the finder of fact, if it is, will make a determination as to its reliability or believability. It's not a foundation question, because the judge already said this person was an expert and there's a sufficient foundation for them to go forward. And he or she made a fair ruling, but it's the second part of that question, I guess, that I struggle with. Does that reliability, does that go to the court or the jury? And my experience is generally that's a question of fact, and I thought that was the core of your argument.
Yes, Your Honor, and to get to the next aspect of this, yes. Here, the judge acted as if he were indeed the fact finder in this case, passing upon the reliability as it applied to my client's confession, as to the believability of the expert's testimony, as it applied to this case as a whole. Indeed,
That's not really accurate, though, either, counsel, right? Because the judge said if it was another expert, perhaps he would allow that testimony. So he was leaving room for his conclusion that this expert didn't meet the requirements of demonstrating that the science was generally accepted, and the second part of that it was relevant to this case. So he didn't say outright, I don't believe this, and I'm not going to allow this testimony. He left the door open for another expert to come in and talk about it. So perhaps it was the wrong expert that testified.
well, Your Honor, the judge's rationales were varying. At times, he also stated that he did not believe that the science is there. I agree with Judge Fahey that this was not an ultimate ruling in the way that the judge should have done so, but the judge did indeed err in passing upon the reliability of this expert's and the believability of it as it applied to this case. And indeed, this case, it was very crucial for this testimony to come out, Your Honor, because while my client proffered a voluntariness defense, he was unable to properly educate the jury on those aspects, those counterintuitive aspects of the phenomenon of false confession.
But counsel, I think Judge Singas raises an important point in that he put out there that another expert could have persuaded him about the reliability of the methodologies that were being talked about to him. So I question, and I grant you, it's very hard to understand what the words, even in context, mean from that Fry hearing, but I posit to you that the judge did not, out of hand, reject the science. He seems to suggest that this could be demonstrated to him sufficiently to pass the Fry test. It just didn't happen here.
I think one of the problems with the judge's decision is that while it suggested a different expert could testify at trial, in this case, the only expert it would have allowed was an expert who had personal knowledge as to my client and personal knowledge as to the circumstances of the interrogation and confession. And that is completely contrary to New York law, and it is also contrary to, an expert is always permitted to base his or her opinion upon, other evidence. And it is also contrary to Bedesi, in which, in doing so, the judge seemed to require that the expert render an ultimate opinion. So to the extent that an ultimate opinion on whether or not my client falsely confessed, which obviously would very much invade the province of the jury. And so to the extent that the judge suggested that would be the proper expert, the judge was dead wrong. And it suggests that the judge's sort of ability to judge, to sort of evaluate the Fry
I
hearing
agree
here.
with you, and I think LeGrand speaks to that as well. That's not the standard, that's not the requirement. You don't need a judge to come in with personal knowledge of this defendant, especially in a case like this where you had another doctor who had direct, diagnostic knowledge of the the dispositional factors that related to this defendant. But I'm not so sure that was the entirety of this Fry judge's holding.
I mean, when you look at the basis of this Fry hearing and what the people did to contest it, I can't stress enough, they didn't put on an expert, they didn't put on any scholarly research or articles themselves, they relied solely on cross-examination. In that regard, they managed to cross Dr. Redlick on three things that we continue to discuss here. One, about whether or not there is criticism of earlier studies, both that she had done, but that others in her field had done. This court has indeed accepted social science research despite there being criticism of early studies. That's People versus Taylor in the rape trauma syndrome area. The other criticism that has been that was picked up by the judge below and has been brought up by the people on appeal is that there's no known error rate as to certain aspects of this. That pertains to self-reporting studies only. In that regard, it is a red herring because self-reporting is an accepted laboratory technique, or rather scientific technique in multiple social sciences. And again, this is something that this court has endorsed in People versus LeGrand, this idea, of self-reporting. And then I think all of this sort of reliability aspect and these questionings about Dr. Redlick, really, this is going to the weight. This is going to the weight as it should go before the jury. The fact remains is that this Fry hearing, this voluminous, lengthy, taxpayer-funded, expensive, multiple expert Fry hearing with numerous articles, scholarly articles, and a white paper entered into evidence demonstrated that even if some of these were valid critiques of early studies, this was known within the relevant community, it was accepted within the relevant community, it was subject to peer review, and it was subject to revision.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. Chris Bluricosa for the Office of Melinda Katz, the Queens County District Attorney. I like the way Judge Garcia put it. The court here conducted a proper Bedesi hearing because the court essentially did an analysis in line with Bedesi, whether the factors that this expert wished to testify to were relevant to the
So
defendant.
counsel, if I may interrupt you, I'm on the screen. Can you be explicit as to where the expert went wrong during, as counsel has already argued, this cross-examination? What is it that went wrong? What is it that she was unable to say or do, apropos of the questions that were asked previously regarding another expert might have satisfied the judge? What's wrong with this expert? What is it that she said or failed to say?
Well, just on the subject of general acceptance, this expert at one point stated with respect to depression and anxiety that although it was not entirely clear, there was, quote, some evidence that people with these particular mental illnesses could falsely confess. And she said there was, I'm just looking for the exact language. Yeah, that's on page 43 of her testimony, not the appendix. Then on pages 45 to 46 of the record, she testified there was some literature that substance abusers were at risk for false confessions. Now, in People v. Williams, now that language is significant because in People v. Williams at 35 New York 3rd, page 37, this court ruled, showing that an expert's opinion has, quote, some support is not sufficient to establish general acceptance in the relevant scientific community. Now, that's just one example. You can look at the articles that she herself authored. One was the comparing true and false confessions among mentally ill offenders. The other was the self-reported false confessions and false guilty pleas among offenders with mental illness. In that article on page 14, she states, although mental illness is a commonly cited risk factor for false confessions, without comparable data from those without mental illness, the rates here must stand alone and should not be used as evidence that mental illness increases susceptibility to making false confessions. And she even admitted that that particular study was a first in two important ways: the first large-scale study of self-reported false confessions and the first study of offenders with mental illness. So doing a first study in an area really doesn't seem like it establishes general acceptance.
So if I'm understanding you, your argument is that the particular types of conditions that the defendant was going to rely on, you're saying her testimony, the evidence, not just her testimony, the evidence at that Fry hearing about what she would be testifying about would not show that the scientific community had accepted those conditions as indeed affecting the confession.
Correct. It's limited to this expert, her testimony. We're not contesting that false confessions don't exist.
Okay, so I'm a little confused then. You're saying that if another expert got up and said, I know that someone said it's only some of the literature, but actually there's many studies on this and they all established this. You're saying that's where she went wrong?
Well, you know, it's interesting you mentioned that, Judge, because they cite, I believe it's in one of the amicus briefs, they cite a 2018 study, which obviously wasn't before the court during the 2014 hearing, where they interview a lot of experts on the subject of what is generally accepted. And a lot of experts stated, you know, in the 80-90% range, this is generally accepted, that's a generally accepted factor, things like that. But what's ironic about that, what's ironic is that then they got to the next category, which was, I'm just looking for the exact language here.
Counsel, while you're looking, where are we on false confession science? If we're not at 80-90% acceptance rate in the relevant scientific community, are we at 51 or are we at 32? It seems as if at some point this science will develop to the point where you won't even need a Fry hearing anymore. It'll be so generally accepted.
Right, I mean, so
But
the
how
things
close are
to
we to
reach
that
that
day?
point, yeah, and again, our position is not that there aren't false confessions out there. We all know that there are. It's reached, popular media to the extent that I think a lot of jurors know this, but we're talking about the specific dispositional and situational factors and how they apply to individual cases. That's what Bedesi is about, because it's two-part. It's not just whether the defendant has a mental illness, it's also the interrogation and how did that mental illness
Let me ask you
impact
this.
that
Has there
interrogation.
ever been a court in New York which has said the science that verifies the existence of false confessions is generally accepted in the scientific community? Is there a case that you can point to that says that?
I mean, I know in this court, in Bedesi, this court did mention that the
No,
defendant
we
in that
mentioned, but
case
we
did
didn't make
have
that ruling.
No, that's the case that comes to mind. I don't know of any court that has said 100%.
I researched it, and, well, let me stop you a second. I researched it, I could find none.
I'll trust your research, Judge.
Well, you know.
I trust you're accurate on that point.
Counsel, wasn't the
But-
point really in Bedesi that false confessions are such common knowledge now that you're almost swinging the other way towards, do you really need an expert to come in and tell a jury that people falsely confess? And the way I read Bedesi is, no, you don't need that anymore. In fact, it's beyond scientific. It's now accepted by pretty much everyone. What you could have is expert testimony on certain factors accepted by the scientific community that lead people to falsely confess. So I think the idea of expert testimony on false confessions, to me, seems to misrepresent what's really going on in a Fry context, which isn't, do people falsely confess? Is that scientifically proven? I mean, that's so proven that you may not even be able to use scientific evidence for that. It's, have you established that left-handed people falsely confess more than right-handed people? And that's what we're going to have a Fry hearing about.
Right, I
So-
mean, but it's interesting you bring up that language in Bedesi where this court did realize that it's become so common. That's the 2018 article that I was referring to. So while they did a survey and, certain experts agreed that this proposition is generally accepted, that proposition is generally accepted, I'll just read a little bit of it here. They were also asked their opinion of whether most jurors believe a proposition to be true as a matter of common sense, and they have a table that shows this. And on one hand, a majority of respondents believe that jurors, like experts, are aware, and then it goes through various factors, are aware that people with intellectual abilities are vulnerable to social influence. That was 66%. And that the risk of false confessions are increased by psychological disorders. Again, 66%. So, it's a funny situation. If that's the current state of the science, yes, false confessions exist, but it's sort of ironic then. What do we need an expert to testify to if the experts themselves are saying people are generally aware of this, as a majority of these experts are
Well,
saying?
counsel, I'll
people are
posit
aware
to
of
you,
this.
I think I read in the defendant's papers that a lot of these factors, especially the situational factors, are sometimes counterintuitive. The things that you think might give rise to a false confession aren't really the ones that inspire it. So let's assume for just a moment that the science, that there's still science to be done, that we haven't gone beyond Fry or beyond Bedesi, and everyone in the community knows exactly how and when a false confession happens. Isn't that the essence of the evidence that was being put to the trial judge
I mean, I
in
think
this
that's,
case?
yeah, and I think to address some of the things Judge Fahey brought up too, this goes to the opinion and what the judge said about personal knowledge. The judge may have pointed out that, well, nobody interviewed this defendant, but he wasn't imposing a rule that you have to interview a defendant. The judge even clarified that in his later oral explanation of his ruling. All the judge wanted was what Bedesi requires, which is, again, it has to be relevant to the defendant and the interrogation. So if the defendant is undergoing a mental health episode or some type of break with reality or something that's connected to his or her depression and that it influences the interrogation to some extent, that's one thing. But if you just have it, sorry, Judge?
Can we put the relevance to aside for just a second and focus just on the Fry issues? Is it your position that the record on the Fry hearing as to no dispositional or situational issue demonstrated general scientific acceptance?
I mean, I think there was enough in the record for the court to take pause and say, this is not the right expert.
No, I'm asking a different question, right? It's not just Dr. Redlick's testimony. There's a huge volume of studies submitted. is it your position that there isn't a single, whether it's left-handedness or it's mental illness or it's depression or, however you want to separate them up, that there's no dispositional or situational factor that there was sufficient scientific acceptance of that would pass Fry? Forget about relevance for a second, because I take your point, it might not be relevant, it might be left-handedness.
I think what the court was saying, though, as to the specific factors relevant to this case, there was general acceptance had not been established. I think that's the core of its ruling. And whether it's based on the literature or the expert's testimony, even in the literature,
That
you
kind of
had...
mushes together the relevance and the Fry hearing, right? I mean, at the Fry hearing, you should not really be asking, at least I wouldn't think you should be asking things like, is this really relevant? That's the expert can testify hypothetically, and that can be linked up or not linked up. That's the way it used to be done.
But the court still has to consider that in light of Bedesia. A court can't ignore Bedesia and say, all right, just do this Fry analysis. A court has to ask, is what this expert is telling us, is this relevant to this case? The expert testified about the Reed technique, about psychological techniques and deception. That didn't happen here. Even from the defendant's mouth, we know that didn't happen here. The detectives were straightforward with him. They said, we have this evidence, these are going to be the charges, you'll be put in a lineup. They never lied to him at any point.
But couldn't that just be a reason to preclude certain evidence from the testimony, but while still allowing the expert to testify? If there's no suggestion in the record that the Reed method was used, and she wants to testify that the Reed method is a situational factor that can give rise to false confessions, just tell her she can't testify about that because there's no basis to believe that that actually happened. But that doesn't go to this larger issue of the science, does it?
Well, the court even said at one point in explaining its ruling, the court said orally, this is on page 1130 of the appendix, so I'm not saying that the science doesn't exist. The court was not saying that false confessions don't exist or that various factors can't lead to false confessions, just that this expert did not establish that.
This expert couldn't connect it, but we've discussed, and we were talking with defendant's counsel for a moment, that it's not necessarily proper for the trial judge to insist that every expert have direct personal knowledge of what happened in the specific case, or even the specific diagnoses of the defendant.
But I think under Bedesia, first of all, by personal knowledge, I can't read the court's mind and know what the court was thinking, but to me, when I hear personal knowledge, you know something about the defendant, not just through an interview, but through anything, police paperwork, a videotaped interview, and you can say, this defendant had a break with reality, and that may have influenced him to make him or her to make a false confession.
Another problem I have is that in looking at the transcript, there were many times when there was a question asked that called for Dr. Redlick to say something about the facts of the case, and there was an objection that was sustained. So it's a little hard to view this as a combined Fry-Bedesia hearing when the expert isn't allowed to testify about facts having to do with this case. And again, my understanding that 100 years ago, you couldn't ask a question of an expert in court about the facts of the case. You had to ask everything purely hypothetically and then use a fact witness to establish the facts that made the hypothetical relevant. That practice has changed, but it just strikes me as the problem that I have is that these two different things, relevance and Fry, got mushed together in a way that's very difficult to disentangle.
Even if the court got the Fry aspect of it wrong, its overall decision was correct under Bedesia and therefore should be affirmed. Defendants that suffer anyone that suffers mental illness, and this is made clear from the record, they are not always in the state where they are suffering from an episode related to their mental illness. We even know that from the testimony the defendant gave at the pretrial hearing. He said, I wasn't going through anything during that second day when I gave my statements.
That sounds like great cross-examination.
Excuse me, Judge?
That sounds like great cross-examination.
Oh, I'm sorry, I didn't mean to cross.
No, if the expert is testifying, that's exactly what you do, right?
Thank you, counsel. Counsel, your rebuttal?
Thank you, Your Honor. I would just point the court to appendix page 585. That's of the white paper. And that unequivocally sets out that at least depression is one of the mental illness diagnoses that is linked to false confession, notwithstanding what happened during cross with Dr. Redlick, and that was entered into evidence. I think what's interesting about my adversary's arguments and some questions from the court, it seems like it really is time for this court to issue a ruling one way or another.
Counsel, I'm sorry, before you get to that point,
Sure.
going back to 585, because
Yes.
I actually happen to have it in front of me, it also says that there is currently little research available to show how different disorders, for example, anxiety, depression, and schizophrenia, potentially impair the suspect's capacity to waive legal rights and navigate through a police interview, thereby suggesting that we just don't know what role those maladies play in false confessions.
Well, I mean, that portion also, Your Honor, states that there is recent research providing a correlation between the two. And, we know that in the mis-ID context, we do allow experts to testify about how there's a higher likelihood of mis-IDs in certain instances. So, obviously, if the court does not want to, consider this particular factor, I want to go to another question that Your Honors had.
Well, Counsel,
which
can
is-
I interrupt you for a second? Sorry, Judge. Which situational factors did the expert, was she prepared to testify on in this case?
Yes.
Situational, other than the Reed method, which Counselor brought up.
Yes, she was prepared to testify about the following 3 situational factors that were relevant. 1, the lengthy custody, isolation, and interrogation cycle. 2, the minimization and theme development that occurred here. And 3, withholding of medication as a specific, situational factor here. And
all
of
those facts were disputed during the hearing.
I'm sorry, Your Honor?
All those facts were disputed during the hearing. For example, the long custody, it wasn't a continuous custody, correct? It was just an hour here, let him sleep for how many hours, half an hour here. We can't really say that it was an interrogation of 24-plus hours.
Right, and the whole point is she should have been able to give this opinion before the jury, Your Honor. She should have been able to say that research says that 24 hours held without, being away from your family.
If the evidence demonstrated that he was away from his family and being interrogated for 24 hours. I guess my point is, if the evidence isn't that, then why should she be allowed to testify to that situational factor if it's not present in the case before the court?
I think I haven't made myself clear, Your Honor. He was in custody for 24 hours. He was interrogated intermittently. So she should have been able to give this testimony to the jury, and the jury could assess whether or not they thought themselves that this affected the veracity of his confession. Because remember, that's what false confession is about. It's about whether this confession is reliable and serves the truth-seeking function of trial. And so the fact that she wasn't even able to get up before a jury and explain that, and same as to the minimization and theme development. I mean, my client testified at the suppression hearing and at trial that the officers said to him, I will give you your medication if you help me. I will let you go home if you help me out. And so again, and then we have a confession from him that says, I was doing drugs, I was messed up, I did some robberies, I want to help the NYPD, will you help me? And so, again, Your Honor, you're absolutely right that we could be skeptical of whether or not this is or not a false confession, but the point is that the jury should have been able to assess that with her expertise before it. And as for factors that were established, Judge Wilson, you asked if there was anything, established at this hearing, and I think as to the dispositional factors, whether we argue or not about, mental illness, I think cognitive impairment has not even been disputed by the people. They haven't written a single thing about cognitive impairment not being, a type of factor that could influence someone. And that was undisputed. It's unanimous. I mean, it's been extant in the case law forever.
Counsel, when you ask us for a definitive ruling one way or another, on what?
That this Fry hearing established that these factors should be able to be testified about before a jury, Your Honor.
But you want us to rule that these specific factors are scientifically acceptable and should be allowed before the jury in every case?
And that's why I'm discussing the factors that I think were established here, Your Honor. And I think that the cognitive impairment at a bare minimum, which the people, again, have not disputed on appeal, they've written not a single word about it, and my client had an IQ of 78, there was nothing in dispute about this. And I think this court has a record in which it can at least rule on that. But, obviously, we think that the court could also rule on psychiatric illness, despite any sort of flux in this that could go before a jury later. And indeed, my adversary is pointing to surveys from 2018. You're right, I couldn't cite them because they're not a part of my record.
Okay, thank you, counsel.